First principles, as those of you, I'm sure everybody in the room will be familiar with the Abernethy case, which sets out that the reason for a dismissal is a set of facts known to an employer or beliefs held by them which cause them to dismiss an employee. That's the starting point. So what is it that the employer believed was the reason for causing the employment relationship to come to an end? But what I think is often overlooked and perhaps more important is the next authority, which I would refer to, which is post office counters and Heavey. That's a significant case because in it, the EAT talks about the order in which the tribunal has to look at reason and then overall fairness. And I think sometimes in particular tribunals, where they can get themselves in a bit of a muddle is by jumping straight ahead to the question of substantive fairness without first looking at and analysing, is there a potentially fair reason for dismissal? And what the post office counters case is, and if I was, and I do when I draft a skeleton argument for an unfair dismissal claim, or if I'm pleading an unfair dismissal claim, put in immediately, is to remind the tribunal that the first step they have to take is there a potentially fair reason? Because if the tribunal finds there is no potentially fair reason, then the tribunal would be making an error in law by then going on to consider the question of substantive fairness. So, first step, has the respondent, has the employer proved that there is a dismissal for a potentially fair reason? If they don't establish that, the tribunal should not, and this is the authority for the proposition, should not be going on to consider the question of substantive fairness. If there's no fair reason, you stop there. Next, and this is something that is, in my view, becoming increasingly common actually, is where you have cases where if you've got a respondent, particularly a respondent who's in person, changing their mind about what the reason for dismissal is partway through the process. Murphy and Epsom, Court of Appeal, it's of course legitimate for an employer to rely on more than one reason, but if it does so, that reason has to be both specifically pleaded and argued before the tribunal. If you get to the point where the tribunal, and this rolls into actually the next lot of authorities, if you get a respondent that changes its position, there should be, if it's not been pleaded, there should be an application to amend. And even if the application to amend is successful, it has to be properly argued in front of the tribunal. If they don't amend their case, they can't rely on the reason. And that ties into the case of Rawat, and then the more recent case of Robinson and combat stress. If there's only one reason pleaded, relied upon and argued, and that reason fails, it will be an error in law for the tribunal to consider whether another reason might have been successfully argued. The first issue is about mistakes on the part of the employer. And there are three authorities that I'm going to talk through about cases where an employer has had a mistaken but genuine belief in the reason for dismissal, and where that can be a substantial reason and therefore a potentially fair reason for dismissing someone. So the first of those cases is the case of Klusova and the London Borough Council of Hounslow. In the case of Klusova, the claimant was a Russian national who was present in the country and working under a visa with limited leave to remain. That visa expired without her having applied for indefinite or permanent leave to remain or renewing any other sort of worker visa status. The local authority obtained advice as to what they should do in that situation. And unfortunately for the local authority, they received the wrong advice. They were told that continuing to employ the claimant in this case would put them in a breach of the immigration rules, and they were advised to summarily dismiss the claimant, which they subsequently did. The claimant, predictably, brought a claim for unfair dismissal. And those of you who are old enough to remember the statutory grievance and disciplinary rules, this was found to be an unfair dismissal at first instance for two reasons. Firstly, a finding which remained untouched on appeal, that there hadn't been a compliance with the statutory disciplinary rules, and so the dismissal was substantively unfair because of that. But it was also found by the tribunal at first instance that there was no fair reason, because what the employer could have done, unbeknownst to them at the time they took the decision to dismiss, was they could have continued to employ the claimant whilst an application for indefinite leave to remain was made. The decision came before the EAT, and the EAT, whilst not touching the issue on substantive fairness, did find that it was a substantial reason, and therefore a fair reason for dismissal, the fact that the employer had a genuine but mistaken belief about the claimant's immigration status, and therefore genuinely but mistakenly believed that they were obliged to dismiss her or being a contravention of the immigration regulations. A similar case came up in an older case of Bukolar and Trust House Fort Hotels. Very similar case. Employer genuinely but mistakenly believed that the continued employment of the employee would contravene a statutory enactment. They were dismissed. There was an appeal. And the EAT in that case said that, in fact, that could be a substantial reason for dismissal. Eli and YKK Fasteners Limited. This is a slight comedy of errors that ended up before the Court of Appeal in 1993. In this case, the claimant had indicated orally to their employer that they were going to resign, and the key phrase here being going to, they were going to resign, and that they'd been offered a job in Australia, which they were going to move to after a certain date. They didn't formally submit a written resignation, but it was found as a fact that they'd been clear enough in what they said to the employer that the employer could take that they were going to leave after a certain date. The employee then changed their mind and decided they didn't want to move to Australia after all. The employer said, well, that's all well and good, but we've actually found somebody else for your job, so we're holding you to the termination date. Their employment was dismissed. There was a first instance claim brought, and it went all the way up to the Court of Appeal. The Court of Appeal, consistent with other authorities in this area, found that because the belief that this employee was going to resign was genuine, and because they had mistakenly but genuinely believed that the employment relationship was at an end, they were entitled to terminate the employment, and it was a substantial reason for dismissal. Part 2 of Everybody Makes Mistakes is a very useful, but in my experience, rarely cited case. The case is Sutton Gates, Luton Limited and Boxall. It's a case from 1979 in the EAT. And in Sutton Gates, there was, this is a case that touched on the boundary between capability and conduct. The claimant worked in manufacturing. There were complaints made by his overseers about the quality of his workmanship. Very decently and bravely, the claimant's employer waited for him to go on holiday and then sacked him without any further warning. He brought a claim to the tribunal, and one of the issues that was grappled with by the EAT on this, should this dismissal be categorised as a capability decision, or was it conduct? And this is a case that is useful if you've got a poorly performing employee and you as an employer are not quite sure whether to categorise it as a conduct issue or a performance issue for someone's performance managed and improved. What Boxall says effectively is that if the employee is essentially trying their best, but they're just a bit rubbish, then that's a capability issue. Whereas if an employer is failing to exercise such talents that they possess, and that's the EAT's phrasing, not mine, then that reason is likely to be conduct. Where that can be interesting as a case for a claimant is if you are trying to defend an allegation of effectively gross negligence. And when you combine it with the Houston case that we're going to come on to talk about later, which suggests that there should be some indication about sackable offences before you sack someone, it can be a useful case to rely on as a claimant. Because if it's a mistake, but it's an honest mistake where somebody is trying their best, but they've been put through a conduct process, a disciplinary process, it can be grounds for challenging that decision. Next topic, which is thorny and causes a lot of problems increasingly, is the old classic, it's not you, it's me, breakdown in relationships, and whether you categorise it as some other substantial reason, or do you properly categorise it as a conduct dismissal? The Tribunal case I've really cited because it's an interesting exercise in how factual attitudes in society have changed. I suspect if these facts were relied upon to dismiss somebody now would be a nailed-on claim under the Equality Act, but I'll run you through them for amusement's sake. This is taken directly from the judge. So the claimant was sacked on the basis that she was a manager of an office of female employees, and her lifestyle, to put it broadly, was disapproved of by the more junior members of staff in the office. This is a direct quote from the judgment. The prime cause of the trouble was not so much Mrs. Tribunal's way of life as the fact that she persisted in introducing it into the office by continually talking about her association. She must have been completely insensitive to the atmosphere, and now here comes the scandal. She already had an illegitimate child and was now boasting of her association with a boy almost half her age. It was not surprising that the other young girls objected to this attitude. And the employer couldn't have dismissed them because of the atmosphere in the office. In our judgment, the employer was taking the only reasonable course that he could in dismissing Miss Tribunal, and we do not consider his action in doing so was unfair. That case is still, I suppose, in theory, good authority, albeit you may want to distinguish it on the facts now for the fact that if there has been a fundamental breakdown in inter-office relations, that can be a substantial reason for dismissal. I would be reluctant, as I say, to rely on those specific factual circumstances for justifying a dismissal. Similarly, the good old 70s, the case of Gorfin and Distressed Gentlefolks Aid Association, in which the employee who was dismissed was found to have been dismissed for being a determined and forceful lady. That determination and forcefulness had caused tension in the home where she was employed, the care home, and so they were dismissed to restore harmony amongst the staff. A more recent and probably appropriate reiteration of those principles comes from the case of Perkin and St George's NHS Trust in 2005. This is an odd case factually, and it's worth going through it in slightly more detail. So in this case, the chairman of the Respondent Healthcare Trust expressed their desire to see the claimant leave his post as the Director of Finance. The claimant was asked by the Chief Executive to resign, but he refused and instead raised a formal grievance against his employer. In response to that, the trust started disciplinary proceedings against the claimant, raising issues as to his management style and his ability to represent the trust generally. And during the course of the investigation process, the claimant adopted a particularly hostile approach to defending himself. Amongst other people, he'd attacked the honesty and integrity of the chief executive, accused several other witnesses of lying, and generally took a bit of a scorched earth approach to trying to defend himself. In the end, the claimant was dismissed, and one of the factors taken into account, which was ultimately determined to be a legitimate one to take into account, was that the conduct at the disciplinary hearing would have led to such a deterioration in inter-office relationships that it wouldn't have been workable for that person to remain in employment. In effect, what the Court of Appeal considered was that where a personality clash had descended to the extent that it led to a breakdown in the functioning of the employer's operation, then that could amount to a substantial reason for dismissing someone. An important caveat to that, though, is that what the Court of Appeal stressed is that it's still for the employer to prove that there had in fact been a breakdown in functioning in the office. And what the Court of Appeal was clear about in its judgment was that vague generalizations about impacts on working relationships aren't going to be enough. The employer will be required to provide clear and cogent evidence that there has in fact been a breakdown in functioning relationships. This talks about specifically where, and it's an increasingly dominant trend, where you see employers who are tempted to go down the road of, rather than outright gross misconduct charges, they will instead rely on some other substantial reason and say there's been a loss in trust and confidence, much like you might in a constructive dismissal claim. There are three authorities that it's very important to consider in relation to this. First is Leach and Ofcom from 2012 in the Court of Appeal. This was where the Court of Appeal, and I think it was Lord Justice Underhill, specifically deprecated the use of loss of trust and confidence as a panacea to try and justify grounds for dismissal on any basis. It referred back to Perkin, which is the second authority, in which the Court of Appeal said in Perkin, and this was reiterated in Leach, if there are specific allegations of misconduct, it is incumbent on the employer, and the preferred approach almost all of the time is for the employer to put your cards on the table and say, we're disciplining you for misconduct. That's the preferred approach because it gives the employee a proper chance to respond. If you have a client who is trying to dress up what should be a misconduct issue as an easy fix of saying breakdown in relationships, advise them against it. If you're for a claimant and you think this has been done, it's a great ground of attacking the decision to dismiss. Because what has been very clear from the appellate authorities is that if this is really misconduct, it should be treated as such, it should be pleaded as such, it should be argued as such in front of the tribunal. And if they've not taken that approach should be avoided. Reiterating the recent decision of Houston, what the Court of Appeal in that again specifically deprecated is that generalised allegations of loss of trust or things, use of buzzwords like there's no insight, lack of contrition, reputational damage, shouldn't be used by an employer to bump up what would be a serious charge of misconduct to gross misconduct. Granger and the Scottish Fire and Rescue Service. This was a case about a firefighter who was forced into ill health retirement against his will. The firefighter in question had been off sick due to musculoskeletal issues for a significant period of time. Following an extended period of absence, he was referred to occupational health, and occupational health said, we don't think there's any prospect of you coming back to work, and so we'd recommend you to be assessed for permanent ill health retirement due to musculoskeletal issues in the back and neck. When the firefighter in question, who, by the way, said he didn't want to be ill health retired, when the firefighter in question was assessed by the independent medical practitioner, the independent medical practitioner made a particularly curious finding. The IMP said, "We actually think you'd be okay to come back to work because of your back and neck issues. But we think," and this is without having spoken to him at all, "we think that you've got some sort of undiagnosed personality disorder, whether that be OCD or something else. And so we think you are permanently unfit for work and eligible for ill health retirement, but not because of your physical issues, because of this undiagnosed personality disorder." It won't surprise you to learn that Mr. Granger, who's the claimant in this case, was somewhat disturbed by being diagnosed with a personality disorder by a doctor who had never spoken to him. When he tried to raise that issue in his stage 3 capability meeting, his manager said, "Nope, the IMP has already made a decision. I'm not interested in anything you've got to say about your medical report whatsoever, and we are ill health retiring you. The decision has already been made." At first instance, the tribunal found as a fact that the dismissal had been predetermined, that none of the key procedural safeguards had been put in place, and that if this had been a capability dismissal, it would undoubtedly have been an unfair one. Strangely, though, what the tribunal said was, this wasn't a capability dismissal. This was a dismissal for some other substantial reason because the claimant qualified for ill health retirement, and found that the decision was completely fair. What the EAT found was that the tribunal had fallen into error in categorising the dismissal as a dismissal for some other substantial reason. In essence, what was said was the tribunal had tied itself in all sorts of knots in trying to draw an artificial distinction between a dismissal which ends up in someone receiving an occupational pension and an ordinary capability dismissal where somebody's sacked and receives nothing. The EAT effectively went back to first principles and looked at, is it a reason relating to the capability or qualifications for performing the work of the kind to which the employee was employed? Well, of course it was. And in fact, in the dismissal letter, what the EAT found was the employer had initially said this was a capability dismissal. Thankfully for me, who'd advised the client at first instance that this was definitely going to win on capability grounds, the EAT agreed with us, has found that the tribunal fell into error, got its tied to all sorts of knots, said, go back and look at what is the reason for dismissal. Was it because of the claimant's ill health? And if so, it must be a capability dismissal. And therefore, the usual procedural guidelines will follow. The matter has been remitted back to the original tribunal for a reassessment of fairness in the light of the findings that the EAT made. And I'm sure I'll be able to tell you all about that next year when I cannibalise that talk for that purpose.